Welcome to the On Your Side podcast. I'm Gary Harper.
And I'm Susan Campbell.
Susan Campbell, the hardest working person around here.
I know, you just caught me. I was sending one last email before we started recording.
So Todd, our audio engineer, and I were up here setting up, and we go past the studio, and who do we see in there doing a Zoom interview at the last minute?
I know.
Susan Campbell.
I literally schedule out my day like to the minute. I squeeze in as much as possible.
I mean, you really do. And then you came up here, and then right before we started the podcast, you were texting. Wow. I mean,
I have a lot of people to talk to, a lot of questions to ask, a lot of answers to get. I don't know. I'm tired, though.
I mean, do you even have time for a lunch break?
What is that?
Yeah, I know.
What's a lunch break?
Yeah, I know.
I had a sandwich at my desk yesterday.
As you were typing and texting and answering the phone.
I had some oatmeal at my desk this morning.
Oh.
It wasn't that delicious.
Oatmeal does nothing for me. Cream of wheat does. That's old school.
That is.
Cream of wheat,
Yeah, that's old school, Gary Harper.
It is. Some of the younger generation
it's
probably
delicious. You used to put a little brown sugar on it.
Oh, yeah, and some toast.
Sounds good.
That is, and it's supposed to be healthy. We'll see. But
Not when you put other things on it.
I think the oatmeal is probably a little bit more healthy. Anyway, so this is a big month. It's October. Do you know what October is?
Tell me.
It's National Estate Planning Month.
Ooh, so that's a good one.
Well, it's important because a lot of people think they don't think of estate planning, and I think people have a lot of misconception about an estate planning. Should I do it or should I not do it? And I think people have this belief that, you need this mansion on a hill surrounded by 10 acres to have an estate, and that's not necessarily the case.
Doesn't that sound nice, though?
It does sound nice. I thought that would be you.
That's not my problem that I have now. Yeah. I think there's also maybe a little bit of just kind of a feeling of not wanting to think about your own mortality.
Yeah, that's true.
I think for some people, it just feels like the easy thing to put on the back burner. I've got time. I'll handle it later.
Yeah.
I'll handle it later.
And then later never comes, and then sometimes later is too late. Yeah. So today we're going to get some answers from Mitch Mitchell. He's a lawyer with a company called Trust and Will. He joins us from Texas. How are you today, Mitch?
Doing great. Thank you.
Hey, thanks for being on the On Your Side podcast. Tell me a little bit about the misconceptions. Would you agree that people think that they don't fall under the category of I have to have an estate plan in place?
I do agree with that. And also, like Susan said, it's not really a pleasant thing to think about. A lot of people don't want to think about it.
So let's dive into this. When we talk about estate planning, that falls under the categories of trust and wills. And it's really recommended for anybody, basically, if you're over the age of 18, that may be a little young, but you should have a trust and a will, particularly if you have minor children. So let's just dive into it. If people don't know exactly what a will or a trust is, let's break this down. Kind of tell us what is a will, and then we'll jump into what is a trust.
Sure. So as you said, an estate plan, it's a will, it's a trust. Another thing we can talk about after I answer the question about the difference between a will and trust is that estate planning also is planning for incapacity. It's not just planning for death. So there are some important documents we can talk about in a minute. But a will it's the workhorse of your estate plan. It's the one document that I think most people intuitively understand. It's something that says what I want to happen with my property when I die. And it's something that says who's in charge of making sure my property goes to the people I want when I die. And so everybody should have one. Every adult should have one, because even if you don't have immense wealth, you will leave something behind. It might be just personal property. If you don't own a house, don't own a car, but you have a chance to say, who do I want this family heirloom to go to? If you don't do that, then there are some default rules. It might be split amongst your family in a way that you don't necessarily want. So that's why it's important for everybody to have a will in place.
Can I jump in right there and ask just what do people need to actually include in a will? How specific or not specific can you actually be? Because, I'm doing the mental inventory in my home right now and thinking, oh gosh, would I have to go through and say, I would love this to go to my children, or is it just obvious that goes to my kids?
Great question. And you can be as specific as you want. A lot of people, to keep it simple, they are not specific. So if I have 3 kids, which I do, if I want them to split the household goods, then usually I'll just say, I leave all my property to my kids in equal shares, and they sort it out. And most of the time, family do sort it out. Now, if there are like some either highly sentimental value items or highly valuable items, then you have the opportunity to call those out as specific gifts. So instead of leaving shares and having them have to figure it out, you could say, I leave this diamond ring to this daughter. I leave my gold watch to this son, and so on.
So correct me if I'm wrong, you can have a will and not have a trust, but if you have a trust, the will is included in that trust, correct?
Correct. So just to clarify, because that's accurate. Again, everybody should have a will, because when we die, there's a possibility for need of probate. And probate's a legal process of transferring property from a deceased person to either their heirs, so that's if you don't have a will, or their beneficiaries, the people named in a will. And as part of the most common type of trust plan most people have, it's called a revocable living trust. And that's supposed to own your property. So you transfer all of your property in advance to that trust so that when you die, you don't have any assets that need to go through probate. Everything's owned by your trust, and the trust says, here are who the beneficiaries are. The trustee has authority without court involvement to go ahead and administer your trust. But as part of a trust plan, we have something called a pour-over will, and it's a single purpose will where the goal is, if I forgot to transfer everything into my trust, like maybe I bought a house and I didn't transfer it into the trust, then the pour-over will says, anything that's in my name when I die, go ahead and transfer it to the trust, because I have a comprehensive plan in there as to what I want to happen to my assets.
So let's break this down a little bit more, because I think maybe some of our listeners, or even I'm overwhelmed with some of this. But if you have a will, which is strongly recommended, but the will is going to go through probate, and a judge is going to decide basically how it's distributed. And that's something you really don't want to happen, because not only does it take forever to go through the probate court process, but you're relying on a judge who really doesn't know you or your family to make some very heavy decisions.
Right. So there's a sentiment there about probate that is just generally out there. And that's, probate's scary, maybe. Probate's something to be avoided. In a lot of states, I think maybe including Arizona, I'm not as familiar with it, probate's not so terrible. So what can make it that process that leaves a bad taste in people's mouth is somebody fails to leave a plan, so they don't have a will, or their plan's incomplete in some way. That's where probate becomes more complicated, because if you don't leave a plan for your family, then your state will make a plan for you. So that's where the judge really just applies the law. They don't have any discretion there. The law says who your heirs are if you fail to leave a will. So your kids might get everything, or your surviving spouse might get everything. It's just you don't have a say in what happens to that. The default rules are being applied, and usually, though, if you leave a will, and I'll use Texas as an example because I know it. If you leave a will that names an executor or a personal representative, whatever your state calls it, and it's a clear plan as to what happens to my property, the probate process doesn't have to be scary. It doesn't have to be this huge drawn-out dispute. In states like Texas, once your executor is appointed, they have authority to go ahead and distribute the property without court order. So it's really just a matter of proving that that was your will. So this is the actual document that said who you wanted to be in charge and who you want your property to go to. And then once that happens, your executor, this person that you trusted to carry out your affairs, has full power to do that without having to go back to court to get permission to do those things.
So that's important. I'm sorry, Susan, but at least in Texas, then, if you have a will and it's spelled out in black and white, it doesn't necessarily have to go through probate, correct?
It does go through probate. So that's the thing. Like in some states, maybe your goal is to avoid probate. I'll use California as an example. It's very, very common for people there to have a trust, especially if you own a house, because you don't want to go through probate. It's expensive. It takes a whole lot of time. And it's expense that can be avoided if you just had a revocable living trust plan. Whereas in Texas, like if I have a will and it's offered for probate, it's not an expensive process. And usually, usually relatively quick.
So,
well, I'm curious, are there drawbacks? It sounds like it's, all roses and super sunny to do a trust. Are there drawbacks or financial implications of doing a trust that I would consider that would prevent me from wanting a trust?
Yes. So there, like most things, there's a trade-off. So with trust planning, I'm doing the administrative work of transferring property while I'm alive. So number one, a trust typically, especially if you go to an attorney to do these things, it's going to be more expensive. We're talking thousands of dollars. Whereas a will plan that includes all the same incapacity planning documents might be like $1,000 if an attorney drafts it instead of say $3,000 to $5,000. So it's more complicated to draft. And then the main trade-off with a trust is the administrative work of transferring property while I'm still alive. So I have to do a deed. If I own a house, I have to do a deed from me to the trustee of my trust to make sure that my trust owns it and that whatever my trust says will control it when I die. Otherwise, any property in my name when I die goes for the probate process. I have to do that for any assets that have a title, basically. So I'll retitle my bank accounts. I'll change beneficiary designations to interface with my trust. So that takes work and extra expense while I'm alive. But the trade-off with that is if I have a fully funded trust, I can go ahead and avoid probate entirely. So I'm saving expense, but really I'm incurring expense beforehand to save expense and hassle later for your family. It's kind of, you can pay for it now and take it out of the hands of your family, or you can kind of defer it and your family will have to take some of that up.
Are you able to remove something from trust? Say I put a house into trust and then I decide to move 3 years later. Can it come out without much of a hassle, or is that another giant expense?
It's not a huge hassle, and that's the revocable part of the trust is I can change my mind about it. So I can revoke or amend the terms of the trust, but also I can take things out of the trust and not have to worry. I mean, there's logistics involved. So if I deed into the trust from me to the trustee of my trust, then later on, if I sell or I change my mind, I have to transfer out of the trust.
So full transparency here. I do not like the idea doing what I do. I don't like the idea of just having a will by itself. And there's a couple, I think I kind of made a couple of points earlier. I mean, majority of them have to go through probate. It takes a long time. It just drags on forever and ever. I'm a big fan of having a trust. Inside the trust, you have the will anyway. And inside that trust, yes, it is a little bit more expensive, right, Mitch? But you have so many other documents in there that make it more expensive. For instance, you have a power of attorney, which would give your loved one, whether it's your spouse or child, freedom, if that's the right word, or authority is probably the correct word, to act on your behalf. And there's a lot of things in the trust. That's just an example. So tell us some other things that are in there.
So, I mean, I want to clarify here because the document you mentioned, so power of attorney, that's something that is part of a comprehensive estate plan, whether you have a will or a trust. So when you have, a lot of people will go to an attorney, for instance, and say, I just need a will. That's the only thing I want. Well, you do need a will, but you also need financial power of attorney, healthcare power of attorney, a HIPAA authorization, an advanced medical directive, or it's also sometimes called or known as a living will. All of those documents that I mentioned, aside from the will, are incapacity planning. And that's something that you'll have in place, you should have in place, whether you decide to use a will or a trust. But going back to the trust and talking about like what makes it the powerhouse that it is, you can do more sophisticated planning with it. It's usually used for more sophisticated planning. So if, for instance, I have minor kids and I don't want them to inherit my property outright because we'll face things like guardianship if I fail to properly plan for them. I instead say, if something were to happen to both me and my wife, I want my kids to get everything equally, but I want a trustee to manage it for them until they reach, say, age 25, age 30. I can make it whatever I want. I can put conditions on the things that I'm giving to people that I can't necessarily do in a will, not easily. So a will is set up where we're just giving things outright to people. A trust is you're telling the trustee, manage it for this person's benefit until they reach this certain age or they reach these certain conditions. Maybe that's graduating from college or graduating from a trade program to say, good job. Now you can get $50,000 from your trust. So that's really where a trust kind of distinguishes itself, because you can be more specific about these things, place more conditions on things, and generally protect people from themselves too. So that's why people like using trust, not just for probate avoidance, but more tailoring your plan for the specific needs of your family.
Who could be the trustee?
Anyone. So most often, a couple will set up a joint trust. And so they're trustees of their trust while they're both alive. Surviving spouse will be the sole trustee when the first spouse dies. And then you can name kids or other trusted family members, maybe even like a financial advisor as trustee to step into that role and manage the trust assets, but follow the directions of your trust, whatever you specified.
Whenever you see movies about somebody who passed away, you always see the big room and all the family is in there, and you have this high power attorney saying, okay, well, Gus passed away and he loved you very much, and then this is what he's going to leave you. He's going to leave you, the house. He's going to leave you the car. I guess anybody, including an attorney, could be the trustee then, right?
Yes.
All right.
I feel like you have probably, even the most well-intentioned families, you've probably seen some disasters unfold, because when you get to possessions and end-of-life kinds of things, there's a lot of emotion involved. Walk me through some of the scenarios that you have experienced or had to coach clients through who weren't expecting maybe a fight. I think there are a lot of families who say, that would never happen to me. My family would never fight. We love each other so much.
So I think, yes, there's always an opportunity for conflict, because first thing that we're dealing with here that a lot of people maybe don't think about is grief. Everybody experiences grief in a different way. And so this is an area or a time when people are grieving and they're not thinking or acting the way that they might normally. And then that's just natural. And so that's where I'll always underscore the importance of having a clear written plan. Because failing that, add to the fact that people are grieving, that they don't know what to do. They don't have a framework for honoring you, knowing what your choices were. And so they have to guess, most likely. And so that's really where conflict most often occurs, where people have to guess. They don't know who you wanted to be in charge. And so if you have 3 kids and you didn't name any of them to be in charge, well, guess what? They all have what's called equal priority to serve in that role as administrator of your estate. So are they going to be able to agree that one of them should serve in that role? Or are they going to be co-administrators, which is a disaster? There's always, like in practice, when I was in private practice doing this with individual families, that was always where the most conflict was mom and dad either didn't decide, or, they didn't decide, so they didn't make a written plan at all, or they didn't decide, so they just decided to make everybody equal and said, oh, well, my 2 sons will do this job together. Well, guess what? It's a job for one person, because anytime you have to get 2 signatures on something, so something as simple as closing out a bank account, have to go in person. And this still is the case, even with all the stuff we do electronically. You might have to go in person to a branch, even though you don't live in that city. And so you have to coordinate travel schedules to go sign something. And that's a small example, but usually they don't get along, and they're playing tug of war with what should be an easy administrative task. But mom or dad could have chosen one of them and said, here's the clear plan about who I want to get what. And if you don't do that, then you set yourselves up for this game of tug of war over who's in charge, whether we're going to sign off on that thing, when you could have just said, this person gets to decide.
I love that piece of advice, because I think, when you're able to put your finger on maybe the one mistake that a lot of people do make, it's so easy to avoid in the future. And what a good message for our listeners that is one easy decision I can make, right? Like, don't spread the wealth in terms of like everybody's an executor. Right.
And I think we may have scared our listeners earlier about the cost. I think you said it was like thousands of dollars for a trust. Can't you get something? I see ads all the time for, create a trust for under $1,000, $800. Is that true?
Yes. So Trust and Will, my company, our mission is to make estate planning accessible for all Americans, because that's one of the things that, that's why we're talking about this month, is 2/3 of Americans don't have an estate plan of any kind. And it's for a number of reasons. We touched on some already. Don't want to think about death, think it's too complicated and or expensive. Well, anybody can make a will. Anybody can make a trust. You don't need to have an attorney involved in that process. You can. That's the traditional route. But platforms like ours, Trust and Will, you can make your own will or trust plan and include those other documents we talked about, the incapacity planning documents, financial power of attorney, medical power of attorney. And we're talking, $150 for a will-based plan that includes all those documents. $600 for a trust-based plan that includes all of those documents. That's available on our website. We're just one of many options. The traditional route, because an attorney is charging you for the time, and most attorneys get paid by the hour, you're talking a few hours of attorney time. And, a place like Arizona, that might be $300 an hour in most of the state. And so 3 hours of attorney time, drafting a will-based plan, that might be $1,000.
Yeah.
There might be estate planning practitioners who do it for less than that, but usually you're talking hundreds into thousands of dollars for a plan if you use an attorney, but there are other options like Trust and Will available to you.
All right. Well, like I always say, I always feel a little bit smarter at the end of every podcast, and I feel smarter now knowing about estate planning, trust, and wills. How about you, Susan?
We just had another adulting conversation.
Yeah, we did. This is very adulting.
It's very adulting.
It is. Hey, Mitch, if people want to know more about you or Trust and Will, where can they find you at? Any websites, anything like that?
Direct them to trustandwill.com. One of the great things about our website is our Learn Center, and it's an area where you can search for free any estate planning topic you're interested in. So we touched on a lot today, but you might have some questions about things we didn't talk about, or you might need a refresher on some of the finer details of the difference between a will and trust. We have a lot of that information available for free on our website.
Yeah, it does get complicated, so that's a great idea. Hey, Mitch Mitchell, thanks so much for being on the On Your Side podcast. Enjoy Texas, okay?
Thank you.
The On Your Side podcast is produced by Brad Denny. Our audio engineer and editor is Todd Martin. Segment producer is Colin Stanton. And I'm Gary Harper.
And I'm Susan Campbell. If you have a problem you can't resolve, maybe we can. Send us a message through azfamily.com or our AZ Family mobile app. Look for the On Your Side section and leave us a message. Thanks so much for listening to the On Your Side podcast. And if you like it, leave us a review. We'll see you next week.
On Your Side is on Good Morning Arizona every weekday morning at 6:45 and 7 o'clock, and every weekday evening on Good Evening Arizona at 4 and 5 o'clock. You can also catch it on Arizona's Family News at 9 on 3TV every weeknight.